Okay, karibu tena for the afternoon session. Let's immediately welcome David to continue from where I picked.
Right.
Karibu, David.
Okay, asante sana. Good afternoon, everyone. So we'll continue with the session. We'll talk about the claims, most of the claim drafting and the practice thereof. And I look at various types of claims, from operators, method, use claims, composition, product by process, biotech, and some claims that are called omnibus claims. So in terms of the structure, I think we've seen how the claim should be. And the structure is that claims begins with a preamble. There's three parts: preamble or the introduction. A preamble, like the case we looked at, would be chair. Then the preamble is followed by the transition term that is called, generally use the word comprising, a chair comprising. Yeah, so the preamble is just to identify the subject matter. What is it? What does the invention relate to? Yeah, it's a chair, a table. Then you have the transition. What does that invention comprise? What are the elements of it, the features of it? But use the word comprising. And then the essential inventive elements. You look at what are these elements. Just like my colleague was showing, F1 up to F4. So those are the inventive elements. And a claim is normally one sentence. You cannot have multiple sentences in a claim. It's just one sentence. Yeah. You cannot have more than one sentence in a claim. The first type of claims are those that relate to apparatus or device claims. And normally it recites in a preamble what the apparatus is or what the device is. Like the case we had in the morning is a chair. That we are already identifying what the thing is. We have examples there. A radio comprising. So the radio is the preamble or the introduction. That is a radio comprising. Then you indicate what are the elements of that radio. A device for hearing music. You've already identified what the device is and what purpose is it for. Comprising, then you have all these elements that are new that you want to protect. We had our example there. We can call it, for example, the category of an apparatus or device. It's a thing. And you have all the starting point are the drawings that you've seen before. And this is the claim relating to that apparatus. Like we said, you start with, it's a container. So up to the point where you have the word comprising, anything that comes before that word is what we are calling the preamble or the introduction, just to know what the invention is all about. So the thing, all that information that's coming before comprising, it's already known. So those features are what is already known. Then after comprising that you have now the body of that claim, identifying the elements or the features that would be protected by that invention. And you have these letters in blue. So that they use as an introduction to the features at the first time. When you mention a feature the first time, it's a container, a string, a tag. Then when you mention it the second time, you use the definite article, the container, because you're making reference to, for example, in this case, that container, the container you're referring to this one that you introduced. So that is the way you do this sort of the claims in general. Then you have the identifier, the numbers there, of which is a technical feature is identified. It's an infusion bag, number 10. So when you go to our drawings, you'll find number 10 down there. That's what you're referring as the infusion bag. Number 11 is what we are referring to as a string. Number 12 is what you are referring as tag. So that way you are able to follow. As you're reading the claims, you can visualize those features in the drawing. Yeah. Then you come to the meat of it, the container comprising. So these are what this person actually is being protected. And it says the container has a receptacle. So you come again to the drawing, you'll find the receptacle is the cup. And people use different names. Different name for this one, for example, would be, can call it a cup. Yeah, just the way the terminology you give it could be a cup. Yeah, would sort of give the same meaning. Yeah, it has a receptacle. And what is the purpose of it? It's indicated there for holding liquid. So if you go through the drawings, you'll find there's 9. That is pointing to the liquid that is held in a container. Yeah. Actually, this thing, it has 2 features. This and the lid. Those are the important part. Like I said in the morning, probably this is not as much because it's already known. By the time this person was coming up with the invention, it was already known. But the critical part would be the lid. Like I said in the morning, you cannot sell the lid alone. So you need the cup because you're selling, what you'll be selling is a complete unit. So that's why it's important you can combine with things that are known, the elements that are known, and the ones that are new. In the totality, that device we meet the requirement of patenting. So you have a lid, and you see from the receptacle, there's nothing much said about it later on. A receptacle for holding liquid. Its job is done as far as you are concerned. Then there's a lot of information about the lid, how it's configured. That's a lid. That is where you have number 1, or in a different drawing, that is it. For the receptacle, just to cover the receptacle, provided with an opening. So you go to 5, you find where the opening is. It's somewhere there. So that whole portion is what is being called an opening. Like a tiny hole there, and the slit across there. So that is the opening. And having a first portion, that opening has 2 parts. A first portion, which is capable of gripping the string, like I demonstrated. And what is capable of gripping is that slit that is there. Because when you pull it up, you bring it to the right. There's a slit there that will hold the string. Because it's a cut for holding this string, which can hang it. If you want to release it back to inside, you remove it from that slit. You bring it to the tiny hole that is there. It goes back. Yeah. Capable of gripping the string of the infusion bag, of the tea bag. It also has a second portion through which the string of the infusion bag can move into and out of the container. So that's what looks like a small hole. That's the second portion of the opening. So you bring it up, you hook it, stands there. You want to remove it, you take it back, it drops back into the container. Yeah. And that is the claim 1 is done. Yeah. So that's one of the things that this person wanted to be protected, just the way it is. And out of it, if it's found there's nothing conflicting, the person can get a patent. But this is just one claim. This is an independent claim. It's a standalone. Yeah. So then there are other claims that follow, which the applicant is looking at additional features. A container as claimed in claim number 1. We talked about that in the morning. We're in the first portion. How do I get rid of this thing? Okay. We're in the first portion of the opening is in the form of a slit. That slit, where is it? It's somewhere down there. It's a slit. That's what's saying that that opening is in the form of a slit, cut into the lid. Yeah. So the claim number 2 is done. It's as small as just elaborating on what is this, the first portion. In the form of a slit, cut into the lid. So it's just an element of putting a slit into the lid. Then you go to, so 2 is a dependent claim because it makes reference to claim number 1. So if you look at claim number 3, it's making reference to claim number 2 and saying we're in the second portion of the opening is an aperture. The aperture is the hole that is there, located on the slit. Yeah, so that's the small hole that is there, located on the slit. So you are really describing in details even the location of all these elements, the relationship between the various elements. Like my colleague said, it's not a list of parts. There has to be a relationship, a connection between the various technical features. Yeah. So, and we are saying that sort of the claims you are narrowing down because you are putting more meat into it. So you narrow down the scope of your protection. Yeah, because claim 1 is very wide. When you bring the issues of the features of claim 2, you are reducing the scope. Claim 3, the same. You are mentioning where the aperture is located on the slit. You go to claim number 4, a container is claimed in claim number 3, when the aperture is circular. Yeah, you saying this is the circular the aperture must be circular. So if somebody makes something that is not circular, the aperture is not circular, there will be a debate whether the person is infringing. But like my colleague said, it's about the inventive concept. Yeah, how much is the person taken from what is patented, and has a diameter greater than that of the string. Yeah, again, you are limiting the scope of your protection of the infusion bag. And basically, this is the way you do the claims. You have to be thorough in what you are describing because you never know when the examiner or the office is going through this document. They may find documents that probably you are not aware of, mention some of these features. And you can go back to your document and see whether there's something that you left out, and you can bring it on board that had not been discovered by the examiner, or is not in the examination report. And that way it's possible you can still amend your application and get a patent. Yeah, so that's about the apparatus. That's the way you do them, the devices. So that's the kind of what you're required to do. This is the category of the method or process claims. So these sort of claims recite the sequence of steps that complete a task or accomplish a result. An example there is a method of making tea. The method comprising, again, you can see it's a method. The intro is a method of making tea, so it's clear from the beginning. Then you see the method comprising. This is the transition. So whatever comes after the word comprising is now what is being protected. Yeah, boiling water, that's the first step. Adding sugar to the boiling water. And one thing you got to note is the connection, the relationship you are creating. You have boiled water. The next step, you add sugar to the boiling water. So you have connected the second bullet with the first one because of that relation you created. What is being added to the boiling water? Step number 3, adding tea leaves to the boiling water to form a mixture. So you formed a mixture by adding tea leaves to the boiling water. Step number 4, you filter the mixture. So again, you can see the relationship that is being created. There's a mixture, boiling water, boiling water, boiling water. So there's a relationship you're creating, and it's easy for somebody else to follow, to understand what is it that you are doing. Then the final step is adding milk to the mixture. And you have your tea according to this method. So that is how you do the method or process claims. The other way, method and process, almost not much of a difference, because you can substitute a process of making tea, the process comprising, so the same sort of thing. So method and process are one and the same thing. Method or process claims, this is a process, but it's a bit long. You can do it as a sentence with the commas, or you can decide to separate them so that it's very clear. Each sort of step is on its own, or can be done a whole complete sentence. So long as one sentence, starting from here and ending where you have the full stop. That's one method, or rather one, it's one claim that is complete. And you can read through it. It's a method for manufacturing a cold water soluble black leaf tea comprising. So after comprising, those are the steps involved. Macerating the black tea leaves, allowing them to ferment, all that. So you end up, if you follow this, you end up with a process of making tea. There are also claims that are called use claims. They're almost similar to method claims. And we have the examples there. The use of substance X as an insecticide. So you discover a substance that probably is there and can be used as insecticide. Or a different version of it is use of substance X for making medicament for treating disease Y. So these are use claims. And most happen in the chemical and pharmaceutical field, where probably the chemical may have been known for a particular purpose. Then somebody else they do their research and find out that it's possible to use the same compound for something else, so that what they claim is the use for that purpose. Sometimes the claims may be interpreted as method claims, and method claims are not good in certain areas. For example, method of treatment of human beings or animals by surgery or therapy. So those ones you want to avoid. So to avoid them, sometimes you use the use claims in order for you to seek to get the protection. There's also what is called the second medical use claims. An example is there, suppose you have a compound XYZ, which is already known and has been used to treat diabetes. So somebody else will do their research and find out and discover that the compound can be used for, let's say, for treatment of malaria. So what they'll do, they'll claim the use of that compound for treatment of malaria, the second medical use. Yeah, the use of a compound XYZ in the manufacture of a medicament for treatment of malaria. It was not being used for treatment of malaria, but somebody has come up, they've done their research and found, yes, this thing can be used for treatment of malaria. And it's normally used when substance is already known. However, there are some countries that do not allow such type of claims. So it also depends with the laws of each country. An example of a second medical use is Viagra. Wanaume tunajua what is Viagra? The blue pill. Yeah. Yeah. Men. So this is a compound that was initially invented for treatment of a heart condition those days. But when the company was doing the human trials, the clinical trials, they found that it had a side effect to the patients who were treating. So it had side effects. And they said, oh, the side effect is even better than what it was meant to do. The heart, there's something else that probably will make more money. Yeah, so the side effects were noted, and second medical use patent was filed. The use of that compound for treatment of impotence, yeah, and became a blockbuster. Yeah, and has killed so many people, so many men, even presidents. A lot of casualties because of misuse of this product. The company also was able to patent other second medical use. For example, I think I saw they have applied for a patent for diabetic complications, for treatment of diabetic complications using the same compound. Yeah. Even a lot of ARV patents were applied back in the late 80s on medical use, because a lot of ARV had been invented in the 70s for other things. Then when the ARV came into being, they tried some of those compounds and they worked. Zidovudine, that is AZT, was a part of it, had been invented in the 70s, but not as an ARV. And they got a patent for the use of it, the second medical use. We also have a category called the composition claims. This again is the area of chemical, of the material or component that I used. An example is a claim for tea composition. Might be tea composition comprising the tea and a certain percentage of other materials. Bacoba manieri, I think it's a plant extract and derivatives thereof. So you have sort of making tea with a herbal composition, a herbal extract. Yeah, so it's that composition that you get protected for. And I think there's a lot of things that are happening, research in this area where you're mixing things and you come up with a better products. There are these supplements that we are buying from foreign countries, Malaysia and all over. Tea combined with something else, with ginger, with all manner of things, and it's a huge market in Kenya through the multi-level marketing, and we are buying a lot of it. But in Kenya, we are not very active in this area where we have tea. Why not combine tea with those other things and make money out of it? Because since there's a lot of Kenyans who are really into this business of buying all these products. Claim number 2 of the same would be a tea composition as claimed in claim 1, additionally comprising that particular percentage of vanillin. So again, you get protection for that composition. Herbal composition is also possible. Herbal composition having anti-allergic activity, including treatment of asthma, which comprises the extract of, again, those people who are in this area of herbal. This is a way that you can get patents in that area, because all you need is identify those herbal things, extracts, and combine them to come up with something that you can be able to make and sell to the public and make money out of it. There is also a category called product by process claims, relating to claims of a product defined in terms of process of manufacture. But these are not very good claims because you are defining a product by not the product itself, but by the process of making the product. Yeah. For example, is a metallic salt obtained by a process comprising the steps of. Yeah, you are not saying what this salt is, but you are defining it by, you are claiming by the process by which it's made. Some countries treat it as a product claim, so they look at the salt, for example, in that claim. So that's what they look at. They'll examine the salt, see whether it's already identified elsewhere. Was it existing? Other countries will treat it as a method. It's not recommended to have such claims, product by the process that is used to make it. Biotech, relating to uses of living organisms. Claim for invention relating to nucleic acids and encoded proteins might be like that, what is there. This is an area that for me is Greek. My colleague would be able to understand those things. I have never touched biology in my life, so some of these things would be hard for me to understand. But that's the biotech claims. And the living organisms, so possible they can also get patent protection for such things. Omnibus claims in Kenya not allowed, where you are making reference to the drawings. A foldable pen substantially as here described with reference to the accompanying drawings. In Kenya, they are forbidden by law. You describe what the product is, not by reference to the drawings. Yeah, it's like you're drawing, you're claiming the drawing. Yeah, some countries do allow. UK and Australia, they allow those kind of claims. Kenya and many other countries, they don't allow those sort of claims. We are making reference to the drawing. Yeah, like the drawings that we're having of the container. Sometimes you find applicants having this kind of a claims, but these are not allowed by the law in Kenya. So we've talked about the independent and dependent claims. Independent is standalone, and the purpose of dependent claims is provide backup in case prior art is discovered that invalidates a broader claim. So just a safety net, adding more features such that you reduce the scope or remove that which the objection that was raised. Yeah. An example of an independent and dependent claim, there a pharmaceutical composition comprising artesunate and lumefantrine provided in combination in a single pharmaceutical dosage unit. So that's an independent claim, standalone. Claim number 2, a composition according to claim 1, comprising from 1 part artesunate to 5 parts lumefantrine, to 5 parts artesunate to 3 parts lumefantrine. So you're adding more features and even giving the ratio of the two substances that comprise this invention. Yeah. Artesunate, that is for treatment of malaria. Coartem.
Yes.
Coartem in combination with the lumefantrine. Yeah, because I mean before these things were known before individually for different things, the artesunate and lumefantrine. Lumefantrine used to be for treatment of malaria long time ago, but they lost efficacy. But then in combination with artesunate, it was reactivated and it was a patent was applied, and it has been used for quite some time for treatment of malaria. I'm not sure whether it's still active or lost its efficacy. There are some claims that are not entertained or should be avoided. A claim to be the inventor of this appliance. So we said in the morning, don't describe yourself. Describe the invention, not you. I should not feature in a claim or in a patent application. I claim that the machine described above is quite new and has never been used or seen before or used before. So that is not a claim, that's a statement. Yeah? I claim some reward for inventing something. So it's not a claim that can be patented. I claim this device is better and more effectual than anything that is known. It's not a claim. I claim the following advantages. That will come in the description. The advantage, when you describe what are the advantages of your invention, but you cannot claim those advantages. They should be obvious from your invention or your claim regarding whatever it was that you have come up with. Designing claims, there are questions to ask. What are the goals of the invention? What am I achieving by this invention? What is the inventor trying to protect? So it's always important. What is it that you can protect? So that is very clear from the beginning, and even in terms of drafting your patent application and also the claims. What is likely to infringe? Yeah, you are looking at the possibilities. What can infringe my patent so that it will help you in terms of designing. For example, what can infringe? If, for example, you are talking about the lead, separate from this, what would infringe out there? And the possibility that probably you don't find companies selling lead alone. It's normally sold together with as a complete device. So that will help you in deciding how do I draft my claims? Who can infringe is the person who is selling this kind of a containers if they put the lid in such containers so that you claim the entire container. Who could license the patent? In terms of the company, who can be able to buy or make use of my container? Yeah. A person that you can license your patent to commercialize your invention. Am I adequately protecting the invention by drafting the claims this way or that way? So there are many ways of looking at it from different pictures so that you get tight protection. And there's also creative. For those who have the experience in drafting them, they can be creative, trying different ways of coming up with the claims. Remember, the purpose of a claim is to indicate what can infringe your patent. Yeah, it's sort of when you're drafting your claim, you are looking at what is that can infringe, so that you get that protection against the infringement. It's not a description of the invention because the description is elsewhere, the detailed description. You claim the solution, not the problem or the aim. Is a solution in terms of the features of those elements that you put through. Yeah, the main claim defines the essential features, and the subclaim defines the preferred, optional, additional features. Yeah, later when you talked in the morning, build your patent claims like an onion. The outer shell is the broadest claim. The scope of protection by the outer, the first shell is much bigger, is much wider. But this may be rejected, as we discussed in the morning, due to prior art anticipation. So you peel off the outer shell and reveal the inner shell, which probably will not be rejected by the office. So that's how you do it. So that's why you have several claims, independent claims and follow-up dependent claims. Yeah. How do you decide which types of claim to draft for a particular invention? Depends on the invention. As you have seen, there are various types of invention, various types of claims that you can put forth, as many as possible. Yeah, you can look at how many claims you can put, you can come up with, and you consider who you can sue for infringement. I think my colleague talked about it in the morning. The audience, who can you sue for infringement? Do you want to go to the small guy in the street, or the big guy who is doing the manufacturing? The supplier. Yeah. Rights of a patent owner are in terms of making an infringing product. So you look at the person who might be making the product, the infringing product, or importing a product that infringes on your patent. Selling, offering for sale. Selling, offering for sale may not be the person who is making. So it's the business person. May not be the one who is manufacturing an infringing product. Yeah, so you need to go higher to a higher person, the source. A person using, maybe that would be including the consumer. You bought it genuinely, and you're not making an infringing product or using a process. So you need to consider who do you target when you're drafting your patent claims. And you may consider combining product and method claims, so that you have a variety of choices. A product may not infringe, but the method of making the product will be infringing, and vice versa. And the beauty of the method claims that the reversal of burden of proof in the process is upon the person being accused of infringing, because you don't know, you suspect that they're using your method that is patented, that is protected. So when you go to court, the court reverses the burden of proof to the person who is being accused of infringing. Just like what you have now with the courts. If you are a public servant, you have a lot of money, and you suspected you have stolen. When you go to court, the court says now the burden is upon the accused person to prove the source of the money. It's not public money. If you cannot prove, the court order is given to freeze those assets. You cannot deal with them. So even in this case, the court reverses the burden. You're being accused of infringing, you're making the product using a patented process, so the burden is upon you to prove that you're not using the process. But don't include every type of claim just for the sake. You've got to be strategic. As you've seen, the choice of words is important when you're drafting a patent. Word means must be appropriate. The meaning of word must be appropriate. Avoid relative words when you're describing your invention. Long, short, tall, they are relative, and there's no precise meaning for some of these words, so you avoid them when you're describing your invention. A tall container. So how tall is tall? A short container, how short is short? So those, they are not encouraged. Thin and flat, so complete, got to be very specific. Sometimes you may also need to define the meaning of your word. For example, T, for purpose of the present invention, means leaf material from Camellia sinensis. So that's the tea plant. Is the leaf material. So you distinguish from instant tea. When you talk about tea, it could be instant tea or ready to drink tea manner, but in your case, you define what you mean by the term that you're using. Yeah, but there's no need to define terms already known in the industry. We are using them consistent with the industry practice. You don't have to define every word that you're going to use. And one of the cardinal requirements that claims must be supported by the description. You cannot claim what you have not disclosed in the description. Yeah, and it has to be consistent of the words and terminology that you use. So if you call something is a frame, you have to use that word consistently in the description and also in the claims. You also need to be aware that there are those exclusions, those things that you cannot patent, depending on the law of each country. For example, we talked about the business method of doing business. In Kenya is not patentable. Method of treatment, Kenya again does not allow method of treatment, but some countries do allow. Sometimes you can change the situation. You know, if it's a method of treatment, you can, instead of claiming the method of treatment, you claim the substance for treatment of disease X. As you have seen, you can change it to a use claim. Yeah, a method of treating a patient having arthritis comprising administering to the said patient a compound X. So instead of that, you have use of compound Y to manufacture a medicament for treatment of arthritis. So it's a use claim, which is allowed as opposed to the method. Because when you claim the method, you are targeting the doctor or the pharmacist who is going to give or to prescribe and dispense that compound or that product. But when you use the use of compound X to manufacture, you are targeting the manufacturer, not the doctor or the pharmacist. So it brings a different scenario. Yeah. Remember, anything that is not claimed is disclaimed. Is not protected. A case study is affordable pen. Yeah, so this is a affordable pen which, and these are the drawings. It's a flat thing. And you have, that's how it looks like when it's flat. Then when you fold it, it becomes a pen. Yeah, and somebody applied for a patent and got a patent for it. When it's unfolded, you can use it as a bookmark. And the person was able to identify the problem with the existing pen. That when you use it as a bookmark, you can make the pages of the book to come out. And therefore, there's need to come up with an improvement of where you have, this device can serve as a pen, you can write with it, and you unfold it and you become a bookmark. and they got a patent for it. Yeah, and that's what is describing the field of invention. When the pen is to be used for writing, it falls into a triangular prism, so it can be easily grasped by the hand. When it's flat, can be used as a bookmark. The background of information, and there's a problem that is identified. This is the problem with the existing pens. Yeah, so then the objectives of the invention, the disadvantage set forth, identify the disadvantage, and they are eliminated by the present invention, which is a pen that lies flat when it's not being used for writing, can be used as a bookmark. Yeah. When the pen is to be used for writing, you fold it into a shape which can be easily grasped by hand, yeah, and use it as a writing instrument. And also, to some extent, you can use it for advertising. When it's flat, when the pen is flat, you can write things on it. Yeah, you can put advertisement or more information about the pen there. So those were the issues that are, the problem that the person identified and the advantages of it. Yeah, statement of the invention, brief description of the drawings. That was the drawing that we have seen, the three of them, and detailed description. Again, you've seen this from the others in terms of the features, the panels, writing tip within it. Yeah, detailed description, and the independent claim, a foldable pen comprising, you have a flat body, and what follows are the various elements of it. And has three elements: a hollow reservoir, a writing tip extending into the reservoir to dispense the ink. Yeah, and some independent claims or dependent claims. A foldable pen as claimed in claim 1, where in the pen tip is a felt tip. Yeah, so a patent was granted for this thing, an abstract, a summary of the entire invention. And the person got a patent. I'm not sure whether they were able to put this pen into the market. The patent they got. So thank you. Questions?
Thank you for that wonderful presentation. My name is Peter Ogalo from Baringo Technical College. I have two questions. The first question is that can that draft or those figures be drawn by freehand drawing?
Mm-hmm.
And then another thing, from your end of expertise and humanist to error, have you ever maybe experienced areas where you have granted patent and then maybe the research was not satisfactory, and then another party maybe had patented the same, come up and maybe challenged the patent successfully? Thank you.
Thank you very much. My name is Victoria. I just wanted to seek clarification. You talked about the tea bags, and something came to mind with this era of corona. People have been making all types of herbal tea and maybe selling in a small way. Do we have a data bank where a lay person can go and find out if this rosemary tea of mine is already been patented by somebody else, or if I'm selling it locally, can I now upscale it? Does KIPI have a place where you can go and look at the lists of the patents that there are, so that you can also avoid starting to make something that's already being sold maybe by a tea company, and you are amending to sell masala tea which is already being made, or mint tea, rosemary tea, all those things people have been making? Thank you.
Okay.
Okay, thank you. I'm Lewis Rugendo from UOE. Under designing claims, you talked about the business methods that you cannot patent. What do you mean by those business methods? I didn't get.
I didn't get the question.
Under designing claims, you talked about business methods and the rest that you can't patent. So I wanted to know, what do you mean by business methods?
Okay.
Thank you very much for the candid presentation. My question is just a concern about the indigenous knowledge. Like, for example, the example you gave about the herbal medicine, and you mentioned Terminalia species. And I'm aware of many other species of trees which my community use for their medical, providing the medical services, the indigenous medical services. So my concern and question is that how will that indigenous knowledge be safeguarded against predators who will, for example, come to a community and take the information and actually go ahead to be the first people to patent that kind of either an active ingredient or a tree that provides those medicinal services? Thank you.
Okay. All right, I think we could answer those questions first. Mr. Chege, there's a question on TK, so you probably are better placed to answer it. How to safeguard indigenous knowledge against misappropriation, especially for some of these the plants that are used by communities for treatment of various ailments. How can they be safeguarded against misappropriation by other people? So that will be yours. The first question was regarding if a patent is granted and can it be challenged? Yes, it's possible, and the law provides for that. That even if we grant a patent, it allows for third parties to come in and object or seek to invalidate that patent. For as long as the patent is alive, it can be challenged by another person. I know that they are required to provide information and evidence that that patent was, the features of that patent were already known, and provide that evidence. It could be scientific journals, other information that was in existence before the patent was filed at KIPI or any other office. And there are patents that get invalidated all the time because even what we do may not be 100% perfect. Not even in the developed countries, they don't have a perfect system. there are certain information that may not be known, and the best prior art normally comes from the people in that field who are doing research in that particular field. They will know the latest information, and there are a lot of patents that get invalidated or revoked, even after they have been granted. So it's possible to invalidate a patent. The other question is the area of the T-birds, whether there are databases which somebody can search. Yes, the databases exist, and I think my colleague will talk about them on Friday. Yeah, he'll talk about there are various databases that you can use to do the search. And we encourage universities to make use of such databases. There are a lot of them that are free. You can also do as a part of your research, or to identify an area of research. You could check through the databases and see the patterns that are there. And I think it's one of the areas that we are looking for collaboration with the universities, so that we provide them with training how to do the searches, online searches in various databases. As my colleague talked about, not reinventing to avoid reinventing the wheel. There are databases that you can access and find out what is there, what is existing, what has been published. When a patent is applied in any office in the world, the law requires that it should be published after 18 months from the time you make an application. 18 months after that, it's published. Publishing means it becomes available to the public, and anybody can even request a copy of that patent application from the patent office, or even download on the internet. There are, a lot of offices have put their database online, and you can access a lot of that information. The third question related to business method. Why can't they be patented? The law does not recognize method of doing business as inventions, for the reason that the way you do or carry out your business should be driven by the market forces. The checks and balances should be the market forces, not through grant of monopoly. TK, Mr. Chega, maybe you could answer that. The concern about misappropriation of indigenous knowledge.
I think yesterday we had a similar question, if it was not exactly the same. But as I indicated, the system for the protection of the indigenous knowledge is still under development. We as yet do not have a very effective way of protecting the indigenous knowledge. But as you probably are aware, there are those conventions that have been negotiated and concluded, especially under the CBD. You have the Nagoya Protocol, you have the Convention on Biological Diversity. I think it's Article 10 and 16 of the Convention on Biological Diversity, which makes some provision on the protection of traditional knowledge. And Kenya is a member of the CBD. But there aren't concrete measures at the national levels that have been effectively put in place for the protection of the traditional knowledge. A lot of that happens through contractual arrangements, but there are certain issues and concepts that have not yet been cleared, especially about the issues of ownership of the traditional knowledge. But we have had those cases where when indigenous knowledge has been used in the development of new inventions, the aspect of benefit sharing. So if they are used in commercial sense, there is need to look into that. And I believe in many of the university IP policies, they make provisions to share with the communities where they get the knowledge for development of any new commercializable inventions. I think those are some of the measures that are coming up. There are negotiations going on at the WIPO for the development of international instruments for the protection of indigenous, that is the traditional knowledge and the expressions of folklore. But as yet, there is still a dream because not much agreements have been achieved so far. And I think they have been learning for the last, is it 20 years?
Yeah, 20 years.
20 years.
Yep.
They've had 44 sessions discussing matters of protection of traditional knowledge and expressions of folklore. So it's still something in the development process. There isn't any well-defined regime for the protection of the indigenous knowledge. But there are measures being implemented, and especially under the Convention on Biological Diversity.
Okay. Permit me to add something there. As Chege says, the issue of indigenous knowledge is a bit thorny at the moment. And I think the major thing is there's a fight between what we call the North and the South. The North has the equipment and the money. The South still has the natural resources. So it is rich in what we call the biodiversity. So Kenya is actually considered the 15th mega-diverse nation in the world. I think the leading should be Brazil, or so those South American countries, should be Brazil or something like that. Because we have the ocean, we have the snow on Mount Kenya, we have the deserts like Sukuta Marmar, where temperatures go up to 70 degrees. We have lakes, the Rift Valley lakes, which are called the soda lakes. We have the fresh water, so basically we have a lot of diverse. Now, when it comes to indigenous knowledge is usually closely tied with the plants, plant material. Now, he has mentioned something called the Nagoya Protocol. So those are the international measures being taken to be able to at least pass benefits to the communities that hold that indigenous knowledge. Because sometimes the science we do is sparked by some indigenous knowledge. Once that's sparked, let's say, for example, Murzik, the charcoal put in there and all that, it just looks like charcoal. But when you check background, that's a lot of science. Why? Those of you who understand there's something being sold called black activated charcoal, and which is used to actually absorb when you have a stomach problem. You can take activated charcoal and your stomach, because it kind of absorbs the germs. You get it? So probably the science behind the Murzik charcoal and the Murzik could be that. And the other thing, so the indigenous knowledge sparks. For example, now you are using, there's something in soap called enzyma. You send sunlight with enzyma. That is a product of, is an enzyme which was used, it replaced the synthetic chemicals that were used in processing detergents. The discovery was done by somebody who was doing, I think, a master's or PhD project from Kenyatta University. And he had mined what we call extremophiles, which is, those are bacteria from Lake Bogoria. And eventually it was taken up by Procter & Gamble and blah, blah. Till now it makes that detergent, which is a lot of money internationally. Where I want to tie in with the indigenous knowledge now, those microorganisms are natural resources in Lake Bogoria. Now the Nagoya Protocol demands that genetic material mined from any region, the indigenous communities that occupy that region must get benefits from that research. Now, the only thing is that when it was done and Kenya discovered it had come from that background, Kenya made noise. Actually, it was not even Kenya. It is somebody smart enough from the Endorois community who live around Lake Bogoria who started taking that case to the international. And of course, with the help with Kenya Wildlife, whatever, they were able to be successful. Now that community today receives money. When you buy that, so there's a money that flows back. I think there's a time they got 2 million. Now I think last year, but they got, I think, 50 million. That money goes to that community. They are using it to educate their children. They're supposed to build schools. So within your community, the indigenous resources you have, whether they are plants, microorganisms, you have to be sensitive about that. Because if somebody does research on that and there's a chemical or something that comes out of it, that community can benefit. But it needs somebody to shout. I'm involved in a project that is working on mining more microorganisms from the soda lakes of Kenya. That is, we are talking about the Bogoria, Magadi, Simbi Nyaima, those kind of things. So if we come up with more resources, more chemicals, more enzymes or something like that, and they become commercializable, the benefits will flow to those communities living in those regions. Because the assumption is, for us to conserve, we must give those communities a reason not to destroy that environment. Therefore, they must benefit from the natural resources that exist there. And the best way is when there's an agreement. So on that part of that project is to organize communities, so that we have a community structure. Because after the plant has been used, who claims? Unless there's a structure of someone who can claim and say this thing belongs to this community. So communities are going to be organized, attached to the county governments, so that if there's a natural resource that will come from those regions, the benefits should flow back to that community. So that is still something that's going on, and that project is meant to domesticate the Nagoya Protocol. So we are still just working on that project. We haven't even completed. We are working with the 4 universities, Jomo Kenyatta, Moi, Rivertex. Rivertex is supposed to uptake any enzymes that will come from that deals with textile. We have biopesticide. There is a company in Naivasha called Dudutech. It's supposed to take any biopesticides that will come from the microorganisms there. And already Jomo Kenyatta has one which is under test as we speak, which we are now supposed to work on the patenting. We have University of Nairobi, which is working on enzymes for textiles. We have KIPI, which is supposed to now turn that into an industrial product. So it's supposed to be a whole process. Now, to get permission to mine that, we had to go to the Eldoret and the Maasai communities, and there's something called PIC, prior informed consent. So that is a document the community the community leaders have to look at, negotiate, sign the percentages and all that. Before they give you permission, you are not supposed to mine. So where we are going, researchers will not do bioresearch unless they get permission from the community. If you publish, you may be forced to get that permission before it's published. If you go to patent that, you will be forced to file the patent with a PIC, permission from the community. That's where we are heading. So whoever was worrying about that, know that that is going to be taken care of in the near future. Thank you.
And one thing that you should know is that if the appropriation is happening under the patent system, there is a possibility of bringing the information to the public if something is already known in the traditional communities. No patent can be given if there is demonstration that going by the prior art, which is found in the traditional knowledge, stories, folk songs, and the traditional, the indigenous mode of passage of knowledge from one generation to the other, or by even practicing. There has been successful oppositions of patents granted in US on the basis of that. Those ones from India. There was the rice it was Pichori.
I know for South Africa, so much for South Africa.
But there has been some
yes.
patents that have been successively revoked on the basis of that the invention was already known and practiced by the indigenous people and the local communities before the filing of the application for registration of that patent. So one way we are fighting misappropriation is there are those civil, especially civil societies, who have gone ahead and sought revocation of those patents that were granted, which were already known by the indigenous people. That's a way of preventing misappropriation. Another way has been to make the information readily available in databases, so that when examiners of patents are carrying out the search, they're able to pick on such information. And once it's available, it becomes prior act to the process of granting the patent. So a patent, the indigenous knowledge would not be misappropriated by somebody. But I hope what you meant by misappropriation is actually somebody claiming that that is his own invention, which is already known by the indigenous people.
Sorry, it confuses me, the role of KIPI and KEBS. Where is your point of overlap? Kenya Intellectual Properties Institute and Kenya Bureau of Standards. Is there an overlap?
No, there's no overlap. They deal with standards.
Yes.
For us, it's about the IP rights,
Yes.
registering the IP rights, the trademarks and patents.
So by the time they are sealing KEBS seal or whatever is being KEBS standardized,
Yeah, that's
KIPI.
probably later on, depending on the product. For example, if somebody gets a patent, the patent does not give you the right to make the product and sell. You still have to follow the other laws. For example, if it's a product, you go to KEBS. You comply with the KEBS standard. Yeah. So if it's a trademark, for example, for water, Coca-Cola had to go and get their water tested by KEBS, whether it meets the standard. Then they are given the mark by KEBS, allowing them to sell the product in the market. But for us, it's just the brand, the name. So in most cases, people will start at KIPI, they register the trademark, the Dasani, then using that trademark, they go to KEBS and get the standard, allowing them to put the product in the market. Yeah, so no overlap.
There is something when Chege was sharing in the morning, I think you talked of the interim, it's like interim patenting and the final. Yeah, provisional, yes. I remember last November when we had our week here, our innovation week here, a number of the cases we had from our students about their ideas, and some were talking of prototypes and so forth, was the idea, was the worry of the idea being stolen. And okay, it was not even students only, some even scholars saying that they are worried that the idea will be stolen before they reach the stage of patenting it. So when Cheki talked about the final and the interim, so to speak, I didn't quite get the period that's allowed to have it on interim registration before you maybe make it final. Yeah. So that time factor, I'm yet to get it because I know that will come again when we have we have another innovation week. Okay.
Okay. So the provisional applications is only valid for 12 months, that is 1 year. So within which you are required now to have completed your research and submit now the complete application, the final application. Yeah, so it's only valid for 12 years. It's a sort of you're preserving the date in case somebody else comes between the date you apply and the time you submit the complete application. You have like a grace period of 12 months within which to complete your research and submit now the complete, which now the initial filing date will be considered as as the priority date that you submit the application. In terms of things like ownership, you are first to go to apply for protection. Yeah, so it's only valid for 1 year within which you're expected to submit the final application. And we don't process, apart from informing you that you have received the application, provisional is not processed. We wait for you to file the final thing, then we commence the process. But we give you a letter saying that yes, we have received your application, this is the filing date and this is the number, and also telling that you are required to file the complete within 12 months. And maybe sometimes you file provisional for various reasons. One, you may be working in an area, research, where probably there's the other competitors coming in, the other people doing the same, and you want to be the first to get the patent. And maybe the time period that the remaining is short for you to conclude the research. So in that case, you can submit a provisional as you go through the final process, the final phases of completing the research. Yeah, so that's the reason why it's good to file provision. And also in terms of competition, for the industry, there's a lot of competition, and companies, they spy on each other. Which area are you working in? Which area are you doing the research? For example, when a company files a trademark, there are others, the competitors, they check. They want to see the trademark you're applying and for which goods or services. So that gives an idea. Maybe there's something you are working on or something you would want to launch. That's why you applied for the brand, for the market. And that also tells them the status, where you are in terms of that product going to the market. So they're ever watching. And some companies even pay lawyers to watch for them. You see, we publish a journal every month, and their lawyers who have given brief, given maybe the name of a company, want you to be checking this company, the sort of things that are advertised by KIPI. Yeah, give that as information. Or even patents. Which patents have been published by who? So all that information, those are sort of due diligence on each other. Yeah. All right.
Okay, one other item, a small one, although we could ask about the same. I read this, I think, almost 2 years ago. I was reading some material from WIPO.
Mm-hmm.
And one of there's a certain occurrence, I don't know the name, I've just forgotten the name, but how they called it, is that there are certain inventors who patent their invention, and their main aim is not to maybe turn it into a product or service. Neither is it for the purpose of licensing it, but they only want to take care to get somebody who will infringe on it so that they can get now paid for infringement. I don't know how they called it. I don't know if is it common in Kenya? By KIPI, for example, do you have such cases? I don't know how they call it. I've just forgotten the name.
NPE, non-practicing entities.
Yes, something like that.
Yeah, so that mostly happens in US. That's where they have those sort of behavior. Huh? Yeah, exactly. Strolls or these are companies that for them they apply for a patent, and their aim is not to market the product, but for them is to, what do we call it? There's a name that is used.
Build a portfolio.
Yeah, and for them is the aim is for somebody to make use of that patent, then they go to court, so that they extract money. They just inform you are infringing our patent. Can we negotiate how much you need to pay us? Yeah, so that kind of behavior. Yeah, the trolls, they don't, they patent, but they don't go ahead to commercialize. They are waiting for somebody to make use of it. Yeah, and then they go to court. Yeah, so and they are, what do you call them? They are just nasty guys who want to use the court system to extract money from companies, and mostly they target big companies who have resources and who want to they want their name to be tarnished. You are being taken to court by a small guy, and you are a big company with a lot of billions of dollars in terms of what you get income, and then a small guy is dragging you to court. So sometimes they opt to pay them off. To get their back. So that kind of behavior. Yeah. So for them, they are always scouting for big companies who are likely to be infringing. And some of those technologies, in most cases, they are very old, but for some reason they were able to get a patent on them. Yeah. So that's how they work.
So it's not a common scenario here?
No, we don't have it in Kenya as such.
Yeah, I was to give an example on the issues of indigenous knowledge, but also what David is saying is interesting. And for me, that methodology, that nastiness, is what we should apply here. That nastiness is what I would actually encourage that we apply. The reason is we are not, but the protection process, especially for patents internationally, is expensive. I tried it in Moi. That was the first patent I applied. In fact, it had been done here by by the Department of Wood Science, and the complications, the costs, which I found even the university was struggling with. Because the most expensive part actually is what we call the patent agents out there. It's by the way a very lucrative business. You should be happy that you are being trained by these guys on issues of patent drafting. Patent agency is expensive, and because I know we can't basically afford, so what do? You protect, throw it out there. Those are the techniques I'm using in Moi. Protect, and then I encourage the sons or whatever, please expose it, talk about it now loudly, so that somebody can steal it. So they can be stolen as quickly as possible. Once this person has tasted the meat and it's in the mouth, then you go and hold it and say, I'm taking it out. You will sit down and negotiate. And that, for me, that is, that's at least the guy has marketed it for you. It's good. So why you negotiate and give the person a good deal? Yeah, that is how, as a poor person, you get out of the mess. That is the bit. Those are the hidden tactics, the hidden techniques. Now, on the issue of indigenous knowledge, you know of the Bushmen in South Africa, so-called. They use the word Bushmen. Some of you have watched The Gods Must Be Crazy. They have. If you look at that movie, you'll see a case
they are
where
called the Sun.
The Sons.
Yeah, the Sun. Yeah.
Sons and Khoisan.
Bushman
yes, Bushman is a bad word. I was looking for that. That's a degrading term. They have those technologies for where it's a cactus plant, which if you take, you can go for a long time without feeling hungry or thirsty. And therefore, the South African research, one of the research institutes was instituted to get the active ingredients. They got them out, packaged some supplement out of it, which is on demand, of high demand in the developed countries. Why? The developed countries suffer from obesity. So that becomes a drug for obesity, where you take it and they don't eat for a long time. A number of people who are eating junk food, that can help reduce the body size for the girls. You are able to fit the Caucasian beauty contest. You can now go and compete. even if your size is beyond what the Caucasian, you know, beauty is something which varies from country to country. In Nigeria and Africa generally, the bigger you are, the more beautiful. Caucasian, the slimmer you are, the whiter your hair, the more cute you are. So in Botswana, if you are a girl with a beard, you are beautiful, the price is high. In Western Kenya and in KIPI, if you have a beard as a girl, it's a taboo. So you see, beauty is not a constant. That's a lie which I think the media is trying to put across. But you can buy it anyway. Because whoever has the media, whoever holds the microphone, determines the rules. Whoever has the intellectual property determines the rules of the game and biases your mind towards his culture or her culture. So those are some of the things dealing with the indigenous issues which we need now to document as universities need to put them in place. That's a challenge the universities have. How do we preserve those indigenous knowledges and even cultures that will help remove some of the nonsense, the biases that actually make you hate yourself? For example, the African girl with the braiding the hair. Most African girls condemn themselves. They say, oh, you know, now we have to make our hair look like Caucasian or Asian hair or Brazilian hair, so what is that? I said, no. Please, as African girl, you should be proud of your hair. Why? You can turn it into anything. You can turn it into Caucasian hair, Asian hair, you can braid, you can put sisal. The other people can't do that. So it's how you look at life. For me, you should be proud. Your hair can be somersaulted into anything you want. So it is an advanced hair, in my opinion. So the sons have that. They have also there's, I think, some tea. So after this project was done, the creative ingredient and the drug is now on the shelves, they worked out there's a percentage that community gets of the benefits of the proceeds of commercializing the active ingredients got from that plant, which was as a result of the indigenous knowledge. Because the issue is not the plant, the issue is the knowledge, the innovation, which the community through whatever means invented. Because inventions is not necessarily a university thing. Even your grandmother can invent. Invention is not a matter of time, it's not a matter of research. For people in the patent office, they will tell you, we listen to any nonsense. We assume the inventor is right. We assume what you are telling us. That's the first impression I have of you. You are telling me an invention. However rubbish is this? I will check the rubbish later. So we don't look at education. We don't look at the language. We look at the idea, the inventability in it. Thank you.
Maybe just to, as we wait for the presenters to, are you done? Yeah, but save this for this thing. Okay. Yeah, I just wanted to say that, in fact, as you were discussing about the benefits of genetic resources to the local communities, I actually was working on something, all of a sudden the Baringo thing came up, the Lake Bogoria enzyme. Indeed, according to what Mbaki was telling us, indeed, the truth of the matter is, in fact, they have been getting 2.3 million from that Dutch company that actually extracted that particular enzyme. And I think they are saying here, there's if you want to study more, you can Google Baringo News, Baringo County News. There is some information on that. It has helped to give bursaries to 200 local students, and some of the money is being used to develop other projects within the area so that they can give them incentive to protect the environment in which that enzyme was extracted for the future. So indeed, the benefits to the community continue to come. And I think based on this agreement that they signed, because I think it was, the thing was extracted around 2015, and I think they managed to, about 15 years ago, and they managed to get, I think the first tranche in April 2014. So indeed, this TK thing and benefits of the genetic resources from the environment can actually come back to the community. Thank you very much.
basically what we are saying is the burden to, you do not just, this knowledge is not just for you. You have a responsibility over your community. Being in the university, you have, or a political, you have now a responsibility over your community's indigenous knowledge and natural resources. You have that responsibility. Anybody working there to do research on your natural resources, anybody working there to do research on your indigenous knowledge, you know those grandmothers and some of the things they have, some of the knowledge. Anybody with a white skin, and you know where we get mesmerized with white skin, you will disclose the information. Yet if you go and that person may not disclose that information. So anybody coming to take that technology, you should be concerned. The secrets of that information is important because it's a communal information. Why? How? Where are you taking it? What purpose? Where are the papers? Have you informed the chief? And some of the chiefs there, what they are concerned about is whether this person is coming to create a political party that is dangerous to the nation. But what we don't know is that there is more danger. So you become, in the modern world, you are the military. You are the military of your community in terms of you got that knowledge, because that's of great commercial value. You really don't know what that indigenous knowledge will do. I'll give you a very good example. Some of the things Africa has lost. In my thinking, probably neurosurgery is indigenous to Africa. The Kisis and Marakwets were doing neurosurgery long time ago. In fact, that is already, there are pictures of people doing that, and it was perfect neurosurgery. Open the head, remove the tumor, and you are back. They sew it back, and you are okay. They say the only thing is the anesthesia, which was tricky. You are given a glass of hot changa, and then some rungu here, it's enough, you know. Then some club is hit where they know where to hit, and you collapse. When you wake up, the migraine is gone. So that kind of indigenous knowledge, indigenous techniques, and those kind of things, food preservation tactics, construction, you see, construction. Because I believe something like a grass-thatched house, there's a way it's constructed. Architecturally, I believe the grass-thatched house is superior to corrugated iron. But the impression we are given is that a grass-thatched house is for the poor. So what we need is our engineering class to do what? To improve it. In Moi University, there's a lecturer, a doctor of engineering. He has gone ahead and improved the granary. So people living in Kitale, I'm sure if you're getting to Kitale, you are seeing this. We launched it last year. It is under patent process. It's in KIPI. I also did the provisional, and when we did the provisional, he had worked with a German university. The professor came to their embassy, informed them. Then we started negotiating with them last year. So I'm actually working on a license so that we go into collaboration, because it's going to revolutionize the preservation of cereals and bio-dried products. Because you only plug your maize in three months. I mean, you plug your maize when it's not completely dry from the farm and throw it there. So it doesn't matter whether it rains or doesn't rain, whether it's at night, maize dries. 3 days, it's enough. You remove your dried maize. Now, I talked to him, Sekando, he said, that technology is actually an improvement of our granaries. So you see, he is a professor who does not assume that the indigenous knowledge is nonsense. He goes and picks the engineering from there and improves it. Why can't the architects improve the engineering of the grass-thatched house? Because it's cool during the day and warm in the night. Yet you are told that's a poor man's house. What nonsense. Thank you.
Professor is quietly asking if Changa is patented. Do you have that information? Now, one of us, Mr. Alkamoi, who works at the School of Agriculture, told me there's something he's doing down there with the community in, I think, Kapenguria or wherever, somewhere. I found it very fascinating that he says, I think they have worked on that program for a while now, and he says actually the area is turning into Canaan. I want us to listen to him for a few minutes and hear what he has to say. so that we can help him, build it up and support it, and maybe replicate in our communities. Mr. Alkamo, please come. What you were sharing yesterday. Okay.
Thank you very much. Maybe can I use a PowerPoint?
You want how many minutes?
Maybe just an overview.
Okay. Yes. Okay. Oh.
Sorry for the... Yeah, it's okay. Just a minute. I've been reminded that there are those who are following us from Zoom, so they will also need to follow my presentation. great opportunity also for us to now gain insights from our facilitators, so that probably in future we can be more robust in looking at what are those issues which can actually be taken as an innovation and those which can be patented. So I'm going to present briefly about the Dryland Safe RN project, which is actually funded by the Mark Knight Foundation. And it started from 2014 to 2022. And this project is trying to work with the community so that we help the community to rehabilitate their degraded landscapes. And you'll find that the characteristics of dryland areas, when you go to the areas of Baringo, Elgeyo Marakwet, West Pokot, Turkana, and in most of the arid areas, you find that soil erosion is a main issue. And it normally happens during rainy season, where you find very deep gullies forming. And with time, it has created a lot of challenges in those communities. So as a project, what we did was actually to look at intervention areas, how we can reduce soil loss and ensure that we have programs that preserve or conserve soil and water, so that we see crop production as well as animal production improving. So these are the research team mates, and our PI is Professor Wilson Ngetich, and we have a battery of scientists who are supporting this process. So we are engaging a community in Chebareria ward, and now we are in about five villages, but we are covering now the whole sub-county. And this program, this is just an overview of what I'm explaining about where we are and where we started. Is in Seneto location. Now actually I've covered about 3 sub-locations in the area, and we are reaching out to about 3,700 people, that is indirectly, but those who we are working on directly are about 406 farmers. And through these interventions, we have looked into various areas, and we started with the soil and water conservation, which at the moment we have built about 101 sand dams. So just an updated version is 101 sand dams. And we have done terraces, about 30 kilometers of terrace. We also, because we thought of if we are solving a problem, then we need to use system thinking to find out how best this can be solved. And through engaging with the community, we identified also that crop production is very key. And we introduced about 21 varieties. These are improved crop varieties from Carlo. And testing with the communities, the 21 varieties, about 16 actually worked best for this community. And those are the ones that they are taking the next level. And because it's a community where livestock is very central, we also introduced fodder crops, where we introduced 3, and all of those fodder crops that were introduced really did very well in the community. And for long-term sustainability, we looked at issues of tree planting, where we initiated tree nurseries within the community and also in schools. And to ensure that also women participate, we introduced a poultry project where we did production or hatching of poultry. This is really to build the circular economy, especially for women. And we provided a studentship where about 6 students have already been sponsored, where 3 have already graduated, whereas 3 are still ongoing. So we have a number of partners ranging from the government and the farmers, as well as local schools, the local administration and the county government, as well as other persons from the central government. So my presentation will largely be pictograms. I'll just be flipping through pictures because I only have 5 minutes. I hope you'll add 1 more minute to finish. And as you can see, this is how degradation is. You can't see even grasses during a dry spell or during dry period. And this drastically affects livestock. You find that the community loses a number of livestock. And without intervention, if soil erosion continues, even after planting, you find that seeds have been washed away. And it's an issue which, based on the experience now, we have went to an extent of actually community, working with the community to appreciate that land degradation is a solvable problem. So we started with almost 5 farmers in the inception phase, discussing with them the issues. And with time, we grew to, that is from one village, we have actually grown the number of farmers tremendously. That is to now about 406 farmers. And our kind of approach is we are using an approach called a farmer research network. So we use farmers, we actually engage with the farmers, they identify issues, and we pre-test the solutions with them so that they choose solution which best suits their situation. And this is a little bit different from the top-down kind of an approach, where this more of now the bottom-up that we talked about yesterday, where you engage with the communities, they test what works best for them, and what works for them is what they're going to implement and use it. And this is really a good strategy of ensuring that we respect the farmers who are actually the primary researchers and appraise the indigenous knowledge to ensure that there is success in research. And we also participated in community mapping, where we identified issues and with the community map out what are the needs that need to be sorted out. And you can see even this map that is on my right, it was the perspective of women, how they were looking at their landscape and the socioeconomics around their landscapes and what are the issues that they will want to get sorted in the area. So the areas marked with red are the gullies, formed probably due to soil erosion. And you see how women also, they appreciate livestock, they appreciate issues of fencing in this picture, and crop production. So the outcomes out of the intervention was that terracing actually have been very effective, because farmers used to say that when just immediately after rains, you will not see any water. And with this intervention, we have realized that water can flow even up to the next rainy season, especially on water points that used to dry early. So with the intervention of terracing and sandam, you find that the water that used to move so fast is now moving slowly in the landscape and getting percolated. And when more water is percolated or saved in the soil, that will result to a prolonged kind of crop production or even producing crops in the next season. And this is an example of sandams where we have done about 101, and it has really helped in ensuring that water is stored in the community. And where women used to walk about 7 kilometers to look for water, now it is very near, it's in their doorsteps. So implying that the time that they actually will have wasted in looking for water for livestock and for their domestic use, they use that time now for other and more productive issues. And you can see from this picture, this is one of the sandams that were built, and you find that it has actually stored tons and tons of soil, and at the same time stored a lot of water, which can take now the community to the next rainy season without a problem. Also, we use stone bands to do along the contour so that we reduce the water speed, especially in areas where it's not easy to work on or to do terracing. And we also encourage the community to do enclosures, that is using live materials to fence their farms, so that to do a multi-purpose, that is to reduce water speed and also to prevent livestock from accessing farms. And these are the crop that we introduced. You can see from this initial picture is that the farmers used to plant what might not be well adapted to the area. Those are the hybrid maize varieties, and you find that without enough rainfall, then this maize will suffer stress. But now adopting more drought-tolerant crops, you find that there is good harvest. And as you can see from this picture of showing diversity of crops which were introduced. Similarly, the community used to store livestock fodder in trees. And with our intervention, we're actually promoting to ensure that the community can actually plant their fodder crops and harvest for future use. And this is a picture also showing livestock eating, this is edible or fodder trees, which is a very common practice in the area. Farmers, they cut edible fodder trees for their livestock so that they cushion them from dying. And we also realize we have opportunities, that is intervening in tree nurseries, where we have actually built about 4 tree nurseries for the community. That is in the community as well as also in the schools.
and we have also seen opportunities of other crops. And currently we are focusing on seed systems so that we ensure that there is that continuity of the production of those food crops that will secure the community from food, nutrition, and security issues. And the other opportunity was about engaging school-going children so that they start learning on environmental conservation issues, as well as also engaging them on more practical issues surrounding agroecology. We have also taken farmers to exchange visits, that is in Ethiopia, as well as also in the eastern part of the country, just to get inspired and to learn from what other people are doing. Thank you. So that becomes the last part of my presentation. And honestly, this presentation was done in 2019. So we have other more things that we have done which I have not shown in this presentation. And maybe given another time, I will actually demonstrate what we have done up to date. So otherwise, without further ado, I just want to say thank you very much for listening. I don't know if there'll be questions or responses, or this is just to inspire all of us. Thank you very much.
Thank you. Thank you, Boniface, for that presentation. Very wonderful. Good work in community. As I said, this is something we can replicate in the community from where we hail. Yeah, it's something very good, and should encourage him going forward. Nah, thank you. Now we are about to come to an end. Before we go for tea and then home, we want to prepare. Dr. Njichi will give a word of appreciation and will pray for tea before we go. But before that, there is a card for this class because we started as curriculum. There is a card that has been given, set by KIPI, which is to be taken by everybody, and the answers should be ready tomorrow morning for further direction. I don't know, Professor, if there will be a supplementary for those who don't make it. There will be a receipt. Earlier is it, okay? Yeah. So, how will you project it so that people get it? Yeah, it's a case, so we take it seriously and return. Yeah, return tomorrow. Check it. Tell us more about the cat. Yeah, you know, already adrenaline is high because of the cat.
Okay. This is the first continuous assessment test. So we want to test what you have learned this afternoon. Essentially, in the midst of COVID affliction, si tulianza kujitengenezea dawa. Si kila mtu anajua vile inatengenezagwa. What are the ingredients? Ginger, honey, lemon. Okay. I didn't put hot water, but you include it. So you know what goes into making the dawa. So tomorrow morning, can you go to the second slide there? Just project the second slide. That is just the same story. We have just talked about it. So there you have the ingredients, the elements that are involved, and you already know the process. Go to the third slide. So your task is to prepare. Your task is to prepare 3 independent claims for our dawa invention. So the first independent claim is about the composition. Okay? Our second independent claim is about the process of making the dawa. And our third claim is about the process byproduct claim. Our dawa made by the process. So there is a product, process, and composition claim. All right? But all these are independent claims. Okay? So you'll prepare them as independent claims. What is a claim? What are the rules that you should observe? You were told this afternoon by David. It must be a single sentence. Okay? It must have the three elements he talked about. There is the preamble, there is the transition, and there is the body of the claim. Munazikubuka. Munazikubuka. The claim structure, the three elements. Kuna watu wataliwind. So mliambiwa there are three parts in a claim: the preamble, the transition, and the body of the claim. So it must have those three elements. The other rule was, when you're introducing an element for the first time, you use the general article, a, all, an. So if you are referring to the same element, okay, subsequently, what do you use? The article there. So that's a rule that you have to observe. The other aspect is the punctuation. The comma, the semicolon, and what else? Where to put the full stop. There is no single sentence without a full stop. But because you are listing several elements, there is the aspect of also using the semicolon. Okay, to separate the various elements of the invention when you are listing them. So observe those rules as much as possible. And I want you to do one thing. You have access to the internet. Okay? You have. I want you to go online to the WIPO website, WIPO, World Intellectual Property Organization, WIPO. The UN body mandated on matters of IP, on matters of intellectual property. Just like you have UNEP, we have WIPO for intellectual property, UNEP for environment, WHO, the UN body for health, ILO, the UN body for labor. So for IP, we have WIP, World Intellectual Property Organization. So I want you to go to that website, just Google WIPO, open their homepage. There is a search there, just search for patent drafting guideline. It will bring you a publication. I have it in my laptop, but I don't know whether sending it there is the most convenient or just downloading it from the original website, because it's easier. It's free. You can download it. This is a book, the second edition. So you download this book. You need it because we can't be able to explain everything about patent drafting in 2 to 3 days. This one gives you the detail in the prose form. It's a guide for how to draft a patent, the things that you should observe. So even the rules that David was teaching you, they are also inside here. You can just open. Actually, I can tell you even the page to open. So for those who didn't get the rules, you don't really need this. You just need to go and download this this module. It's module 4. It's module 4, which is found from page 36, 36 to 60. Page 36 to 60. Theory of the patent claim format. It's there. So you can if you still didn't get the Nini, but David can also, the Nini can also be circulated, the presentation. No problem. So you can see the rules for writing a patent. So that should help you get through the exercise. But those who have been following, these are simple, very basic exercise. But those are the tips that will be used in marking your exam anyway. Is it clear? Just spend it's a few minutes in the evening or tomorrow in the morning before we start. You should have completed. So that we start by reviewing as a way of recapping what has been learned today. Today.
Thank you. Thank you. With that, I think it's been a good day. We appreciate you and invite you tomorrow morning at 8:30 for the next day 4. We'll ask Dr. Victoria Ngichi to come and appreciate the team and pray for the type of team. Then that close the day.
Thank you very much. Yes, good evening, everybody. We cannot take this for granted. It has really been a day full of learning, isn't it? They've even given us an open book assignment. Yeah, so we don't have to go and run, we just go and open the website and read the lecture and do it. I really want to appreciate our resource people. You have really shown us the things which we take for granted, like the process of making tea. Really, I can claim it. But so long as people are just making tea for their houses, now at least I know. I cannot tell everybody to stop using that method if they think it's mine. But it's really shedding a lot of light on us, and we really appreciate KIPI for even taking the time to bring all of us together from different institutions, and we are really grateful. It's very fresh in my mind, Dr. Mbayaki's presentation some time back in this same room when he brought these issues to us, and they were looking very far-fetched and new, but I tell you, he really planted a seed in us. And when we realized this was being called, some of us, that's why we are here all this time, and even some of the people online. I want to believe we are headed somewhere, not just as an institution, but as institutions of higher learning. We are not just the people who teach or lecture, we are actually building something for others to build on, isn't it? We are leaving behind something to be built on. So with that, I want to thank each and everybody who has sat through it. There are people who've been consistently here, and we really want to appreciate the keenness you are showing, and we know it shall not be in vain. You will not leave this place on Friday the same way that we came in, isn't it? So thank you very much, the organizers, Professor Liz Mamburi and team, and we are even grateful to the University of Eldoret for having provided all these facilities, and the kitchen team. I want us to stand up and pray as we prepare to go. Yeah, let us pray. Our Father and our God, in the name of Jesus Christ, we want to thank you because you're the divine joiner of groups, and this is a group you've divinely joined for such a time as this, to be even to have these things introduced unto us in our everyday life, that we shall not just be lecturers or teachers or just leaders in our institution, but we shall see things from the point of view of what has been revealed to us. We thank you for our resource people. Indeed, since morning today, they have labored on the theory and practice of claim drafting, and we just want to pray that these things shall stick with us. Even the assignment that has been given to us is going to help even to solidify it in our mind, in our everyday work. We thank you, Lord, for being with us since morning. Thank you for the food we've eaten and even the tea that we are going to take. Father, after the tea, we are going to our various destinations. We pray for our resource people that you'll strengthen and refresh them. And each and every member of this team who are going to various places, may your safety and security go with them. To the glory and honor of your name, we pray with thanksgiving. Amen and amen. Thank you.